In this video, I'm going to share all the unlawful ways human resources refuses to accommodate employees who are having a health issue. If you want to know if your employer is violating America's reasonable accommodation laws, then keep watching. My name is Branigan Robertson. I'm an employment lawyer. This is part 3 in our reasonable accommodation video series. In part 1, I told you that the most common reason Americans get fired in violation of the law is when the employer is unwilling to reasonably accommodate the worker when he or she becomes disabled. In part 2, I explained what qualifies as a disability under the ADA and what the most common reasonable accommodations are. This video will expose the dark underbelly of accommodation denials, how they happen, and why. But before I get going, you should know that although I'm a California lawyer, I'm making this video for workers all over America. But this is not legal advice. This is YouTube. If you need legal advice, you should pick up the phone and call a lawyer in your state. If you worked in California and you were fired, you can call my office for a free consultation. I'll put my contact information on the screen at the end of the video. The Americans with Disabilities Act, or also known as the ADA, says that it's unlawful for an employer to fire a disabled employee who has a physical or mental health issue so long as that employee can perform the essential functions of the job with a reasonable accommodation. In the last video in our series, I went through a long list of physical and mental impairments that qualify as a disability under this law. But I realized I forgot to cover some of the most common issues we get calls about: depression, anxiety, and stress. Under the ADA, transient or temporary emotional conditions such as depression, anxiety, and stress may be considered disabilities if they result from an actual physiological or mental disorder. In contrast to that, if the depression, anxiety, or stress is triggered by a personality conflict with a particular supervisor, or simply due to the supervisor's standard oversight of the employee's job performance, that does not establish a disability, right? Work is sometimes stressful. Just because you are stressed one day does not mean you are disabled. Sometimes work makes you a little sad. Just because you're sad one day does not mean you're disabled. To be clear, depression, anxiety, and stress may qualify as a disability so long as it results from an actual physiological or mental disorder. So it's going to be very important that you work with an actual doctor to substantiate this. Medical records from a licensed physician are key to proving this element. Now remember, at the end of a trial, at the end of a case, a jury of your peers is probably going to decide your fate. Winning in front of a jury is hard, and you're going to need all the help that you can get. Medical records are key to winning most reasonable accommodation cases, especially ones regarding depression, anxiety, and stress. Now, before I can describe all the shady ways HR refuses to accommodate employees, we have to talk about the employer's responsibilities under this law. What are the employer's legal obligations under the ADA once they find out a worker is disabled? Once an employee becomes disabled, okay, HR is required to participate with the disabled worker in the interactive process. More specifically, the interactive process is essentially a good faith conversation between the disabled employee and HR. And the whole point of this ongoing conversation is to find a reasonable accommodation for the employee so he or she can perform the essential functions of the job. This conversation can be in person, can be over the phone, or preferably, it can be entirely in writing via email. once the employee requests an accommodation or the employer becomes aware that the employee has a disability and an accommodation might be needed, the employer is legally obligated to initiate this interactive process. Moreover, the interactive process is a continuing duty that is not exhausted by just one effort. It's an ongoing process because most medical conditions and most jobs are not static. They change rapidly, right? So, okay, what is discussed in this interactive process? Well, essentially, the employer is obligated to do 4 things during the interactive process. Number 1, they need to determine, or they need to analyze the particular job involved and determine its essential functions. Number 2, they need to consult with the disabled worker to learn his or her precise job-related limitations and how a reasonable accommodation could overcome those limitations. Number 3, the employer is required to identify any potential accommodations and assess their effectiveness in helping the individual employee in performing the essential functions of the job. And number 4, the employer is required to consider the individual's preference and select and implement an accommodation most appropriate for both the employee and the employer. Now, the thing that companies should know is that the law is very clear. An employer fails to engage in the interactive process as a matter of law if the company rejects the employee's proposed accommodation and offers no practical alternatives. The employer must participate in the interactive process in good faith. Now, if the interactive process breaks down, the court is going to attempt to find the cause and assign responsibility. For example, often the cause of the breakdown is missing information. When the missing information can be provided by only one of the parties, the party withholding the information is probably going to lose. A good example of this, and one that's very common that I see, is if the employer requests a doctor's note outlining the employee's limitations, and the employee never gives that doctor's note to the employer or to HR, that would be the employee's fault, and the employer will likely be found not liable for failure to provide an accommodation. Well, okay, let's go through the 7 common ways that HR or management unlawfully refuse reasonable accommodation requests. Number 1, HR will claim, "We didn't know that you were disabled." This is one of the most common strategies HR and management uses to deny accommodations. They say, "We didn't know that you were disabled." It's easy to see why they claim this. One of the key elements to winning a reasonable accommodation case is to prove that the company knew that you were disabled. After all, it would be fairly difficult, actually it's impossible, for a company to discriminate against you for your disability if they didn't know that you had a disability in the first place, right? Well, while this can occasionally be a valid defense, this is usually unlawful because of 2 reasons. Number 1, most competent employees tell their employer in writing about their disability. If they don't do it in writing, they usually do it verbally, and there's usually witnesses to testify to that. Number 2, even if the employee does not expressly tell the employer, in many circumstances, the court will reject the "we didn't know" defense because the symptoms the employee was exhibiting were obvious signs of a disability. In essence, even if the employee didn't expressly tell the employer, the court will impute that knowledge onto the employer because it was so obvious that the employee was disabled. Number 2, HR will claim the employee never requested an accommodation. Now, generally speaking, it is the responsibility of the disabled worker to request a reasonable accommodation. That request traditionally kickstarts the interactive process that we talked about before. If you are disabled, it is best practice for you to request an accommodation if you need one. However, when the disability is obvious, sometimes it's not legally required. As a result of this confusion, HR will frequently claim later on in a lawsuit that the employee never explicitly requested an accommodation and therefore the employer didn't need to give him one. But this is usually incorrect. Once the employer becomes aware that the employee has a disability that may impact their ability to do their job, whether that is from a doctor's note or they just observe it with their own eyes, the employer has an affirmative duty to initiate the interactive process to try to find a reasonable accommodation so that the employee can do the essential functions of the job. They are not allowed to just fire the disabled worker because he or she didn't explicitly make a request. Employers are not allowed to fire a disabled worker unless they have fully exhausted the interactive process and it is clear that no reasonable accommodation can be made that would allow the worker to perform the essential functions of the job. Okay? Number 3, they will often claim that the employee is not eligible for FMLA. This one is really sneaky when you think about it. If you watch the first and second videos in this video series, you know that a temporary leave of absence can qualify as a reasonable accommodation. Now, this is separate and distinct. This is a separate legal mechanism from the Family Medical Leave Act, FMLA. But a lot of HR representatives either don't know that or they pretend that they don't know that. Because traditionally, when the average Joe thinks about going on a leave of absence from work, they think they need to go on FMLA. FYI, I've made an entire video on FMLA if you want to know whether or not you qualify for that. But my point is this. Most people don't know that they don't have to qualify for FMLA to take a short leave of absence. You can go on a short leave of absence via the reasonable accommodation and interactive process mechanism that I've been detailing in this video series. So for HR to deny your leave of absence because you don't qualify for FMLA is a red herring and it might be a violation of law. Number 4. HR will frequently claim that the employee never submitted a doctor's note. When you request an accommodation, the employer is absolutely allowed to demand proof in the form of a doctor's note. Generally, the employee must cooperate in good faith with the employer by providing reasonable medical documentation. So generally, yes, you are required to submit a doctor's note and the employer can deny your request if you refuse. However, the requirement changes when the disability is obvious. Here's an example. If you had your finger amputated in an accident and then you requested a reasonable accommodation, you probably legally don't need to submit a doctor's note. Your disability is pretty obvious because your finger is missing, right? Now, most disabilities are not that obvious, so getting a doctor's note is important. But just because you don't submit one doesn't mean your employer is off the hook. I'm going to cover best practices regarding doctor's notes in the next video, and it's extremely important that you watch it when you finish this one. Number 5, HR will often claim that providing a reasonable accommodation would be an undue hardship. The most common reason HR will unlawfully deny your reasonable accommodation is that they will say that your request will cause an undue hardship on the employer when it actually doesn't. Well, what is an undue hardship, Branigan? Well, the first thing I should say on this is that context really matters. Each and every case is different. With that out of the way, from the law's perspective, an undue hardship is defined as an action requiring significant difficulty or expense when considering the following factors: the nature and cost of the accommodation, the overall resources of the company, the impact on other employees' ability to do their job, and the facility's ability to conduct business, the type of operations of the employer, and geographic considerations. Since these factors change considerably from one employer to the next, the answer of whether or not your accommodation request causes an undue hardship on the company changes from situation to situation. So to summarize, a company is legally allowed to reject your requested accommodation if it actually would cause an undue hardship on the company. But it's difficult to give a bright line in a video what is or is not an undue hardship in a YouTube video because it changes on a case-by-case basis. Here's a really good example. Let's say your doctor has ordered you to work from home for 6 weeks. So you contact HR and you request exactly that as an accommodation. That might not be a problem for a Fortune 500 company, but it could be an undue hardship for a company that employs only 4 workers or 5 workers. Here's another example. Let's imagine that you don't qualify for FMLA, but you do need 3 weeks off for surgery and 2 months of light duty where you're not allowed to lift more than 15 pounds. That would probably be fine for a bookkeeper position, but the same exact request might cause an undue hardship on a company where you're the only shipping and receiving clerk. Like I said, context matters. What does all this mean? If you've requested a reasonable accommodation and HR or management are denying it, claim that it would cause an undue hardship, the company might be breaking the law if the factors we just discussed fall in your favor. Again, we're going to talk a lot more about this in the next video in our series. Number 6, HR will claim or HR will change the essential functions of the job in order to deny your accommodation request. Every job has essential functions. What are they? Essential functions are the fundamental job duties of the employment position. Remember, the employer is not allowed to fire a disabled worker if he or she can perform the essential functions of the job with a reasonable accommodation. So one of the sneaky ways HR can attempt to get around this law is by changing your essential functions. The best way to explain this, again, is with an example. Let's pretend you work all day in a cubicle, typing on the computer and talking on the phone. Let's say you break your ankle and the doctor slaps on a cast, puts you on crutches, and instructs you to elevate your foot for 6 hours a day. This should not be a problem when your job's essential functions, right? All you do is get a chair and elevate your foot, and you can keep typing on your computer and keep talking on the phone, no problem, right? But for whatever reason, let's say your manager doesn't like this and prohibits you from elevating your foot at work. So you submit an accommodation request with HR asking that you be allowed to elevate your foot during the workday. Should be no problem. Considering your duties and the minimal costs associated with this request, it's totally reasonable. But as opposed to granting your request, HR suddenly decides to transfer you to the warehouse, where you will have new job duties requiring you to walk several miles a day. And then HR says, in light of the transfer and change of your job duties, we have to deny your accommodation request because it would be an undue hardship. This would be a blatant attempt to circumvent the company's duties under this law. A good lawyer would see right through that kind of BS. All right, number 7, and finally, what if HR suddenly fires you for something unrelated to your disability? Let's say you've worked at a company for 5 years with nothing but accolades and stellar performance reviews, and then you get diagnosed with some sort of serious medical condition, or you get pregnant, or something like that that interferes with your ability to do your job. Soon thereafter, you work with your doctor and you request a reasonable accommodation. But during the interactive process, right, you've been a great employee. Suddenly, you get your very first write-up for poor performance. You've been a spectacular employee, so this takes you completely by surprise. And then during the interactive process, they say that they have serious concerns about your declining job performance. They're telling you this, but you're still performing at a high level and you haven't made any significant mistakes. Then they go ahead and grant your reasonable accommodation, but it was a total farce because 3 weeks later, they simply fire you for continued non-performance. This is a classic example of what in the law we call pretext. Pretext is when a company fires you and lies about the real reason why they fired you because the real reason was unlawful. They are not allowed to fire you for having a disability or requesting an accommodation. If something like this has happened to you, I strongly recommend that you contact a lawyer in your state. If you're in California and you got fired like this, please give my office a call for a free consultation. Now, if you are listening closely, you now realize that there's a lot of sneaky ways HR and bad managers can unlawfully deny your accommodation or fire you. The next video in our series is called How to Request a Reasonable Accommodation. I detail best practices in how to request an accommodation to minimize the chances of retaliation and maximize the chances that your request will be granted. I also cover how to lay a legal foundation that you will be able to use if your employer fires you so you can hold them accountable in a court of law. It's probably the most important video in this 5-part video series. If you found this video to be helpful, please hit the subscribe button and hit the like button. If you know somebody who should also know this information, please share this video with them. That's all I have for you. Have a great day.